Yes, welcome to the No Say Project for May 20th, 2017. I'm your host, Marc Stevens. Of course, the website, markstevens.net. You're listening to the 3 hours of Anarchy Radio right here on LRN.FM. That's the Liberty Radio Network, where we're here live from the Fortified Compound most Saturdays from 1 to 4 Pacific Time, 4 to 7 Eastern Standard Time. And for those down under, it's Sunday morning, and I got to give a special recognition to Matthew. He was on the show not too long ago. He posted on the forum from Brisbane. Appreciate the helpmate with getting another computer. Calvin has got that, and it's going to go a long way, if not, pretty much covering what we need for a really good machine to do video streaming. And I tell you, if it, depending on how time is, maybe I'll bump it up more than just the video stream on Wednesday, but we'll see what happens. But a big thank you to Matthew in Brisbane, and of course to everyone else that supports the show, but a big one to Matthew from Brisbane for his continued support and for helping get another machine, another computer that can handle live streams and where it won't take 6 hours to render a video. Got a lot of stuff to get to today. If I post this, we're going to do a little bit better than this. But Ginger is in town of Soulless Productions. He's been on the show before, and usually good news when Ginger's on the show. He hand-delivered me these yesterday. These are 2 orders from court in Bexar County. I see, I remember how to pronounce it. It's spelled B-E-X-A-R, but it's pronounced Bear. Bexar County there in San Antonio, Texas, and I'll get to that, but we have 2 more tickets thrown out there. Listen, if you want to join the big show here today, let me give you the call-in number for that. It is 218-632-9399, 218-632-9399. The passcode is 2020 and the pound sign. That's 2020 and the pound sign. You can also reach me on Skype, and that is Frank Rizzo 3. Frank Rizzo with the number 3, and that will get you in. Don't call me directly, but instant message me there. For holy crap, I just looked at the board, and we've got a full boat of calls already. Wow. I'm not actually connected to the caller line just yet, so I'm going to ask everybody to bear with me for this first segment. And I don't like to bring people up on the first segment anyway, because the first segment and the last segment is always shorter than the other segments, the middle 2. And that's because of those commercials. And I know we wouldn't get to have a show on Wednesday, but that is taken care of. We have no commercials on the Wednesday broadcast. So if we don't get to everybody, we will do it there. But I just something real fast from the news. I don't think I've ever heard the phrase on a radio broadcast before, tearful wiener. Okay. Oh, man. Okay, but then let's get to the heart of the matter here. We've got a really big trial coming up in New Hampshire with our friend Bill of the Twin Mountain Country Store, where they are coming after this peaceful man, admittedly peaceful man, who's not accused of hurting anybody. They are coming at him with everything they've got, basically. These people who have admittedly don't have a shred of evidence and don't think that they need evidence. They're so violent. They're so god-awful arrogant. They will actually say, we don't need evidence. We don't need evidence. Some of them have lied and said, well, there's got to be evidence, and legal opinions and citations are not evidence, and then they turn around and use the RSA anyway as if it is evidence, which it is not. So what we want to do is to help Bill and everybody else. We got to make it a regular part of the show. I know I always tell people you got to get into the chat. You got to role play. You got to take the script and you got to role play. And you got to focus on cross-examination, because the principles that you're learning and what you're doing when you're learning the cross-examination are going to apply when you're questioning at arraignment. It's always a cross-examination. Always. We've even had judges say, I'm not here to be cross-examined. Just because I'm asking you a question doesn't mean it's literally a cross-examination. But the cross-examination, very, very important. Something I quoted in the books where the Supreme Court has ruled many times that the sine qua non of the adversarial process is the cross-examination. They have come out and said many times that the cross-examination is the best tool that we have for determining the truth of something. So let me see where, and I'll put this in the show notes. I guess I probably should have had this set up before we started doing this. I guess I was laughing too much about the tearful wiener. Kind of. Yes, it says the cross-examination is regarded as a sine qua non, which is the be-all, end-all. It is the most essential part of a trial, the adversary system. According to one legendary scholar, the art of this mode of interrogation is alleged to be a practice as old as the history of nations. While the validity of the historic claim made by Francis Wellman is open to serious dispute in both this country, being the United States, and across the world, the centrality, the centrality of cross-examination to accurate fact-finding retains its mythic and precedential value. Judges and justices of courts at all levels continue to find cross-examination not only a necessary, but also a sufficient method of confronting a variety of trial evidence and burdens. As Wigmore once trumpeted, it remains in the eyes of the law, and those rational people, as in those of many practitioners and scholars, the greatest legal engine ever invented for the discovery of truth. Okay, and this is from by a Jules Epstein, cross-examination seemingly ubiquitous, purportedly omnipotent, and at risk. Now, I know, regular followers to the show, you're laughing right now because you've gone to court and you've seen that the judges, traffic court judges especially, and tax court judges, equally notorious for this. They have so much contempt for the cross-examination process. They have a contempt equal to a defendant's cross-examination as prosecutors have about Brady requests, okay? That's some serious contempt, all right? Anyone who's ever tried to cross-examine a police officer in court knows that they are contemptuous. And they lie, and they lie, and they lie, and they will lie. And then they'll lie about lying to get around their denying of a valid an effective cross-examination. Now, there are many, many cases that hold that a denial of cross-examination without waiver is a constitutional error of the first magnitude, and no amount of prejudice is necessary to, or can cure it. No, you don't have to show prejudice. If they denied you an effective cross-examination, end of discussion. That's one of the worst errors a judge can commit because that is the be-all. It is the greatest legal engine ever invented for the discovery of the truth. So why, when we go into these proceedings, do they have so much contempt for us when we try to do a cross-examination? Because they're not interested in the truth. All they're looking to do is put on a dog and pony show so that they could, he got his day in court. So that when it goes up on appeal or in the court of public opinion, they can say he got his day. He got to cross-examine and then they'll lie. Well, the judge has discretion to limit cross-examination to relevant questions. No one's arguing that. The fact is, they lie about what's relevant. Yeah, they do. Yes, they do. And we'll get to that. We'll probably go out of order here for what is actually video that's uploaded for this show because I want to get to the calls. So we will pick up where I left off after the calls when we get back here on the No State Project. So don't go away. We got a lot to get to. Welcome back to the No State Project. It is Saturday, May 20th. And I'm coming to you live from the Fortified compound, of course. The number, I'm not going to give out the number. We've got a full line of calls already, which I was a little bit surprised when I looked at that at the beginning of the show. I appreciate it. We got a lot of people to get to. We're going to do our best to get to everybody. So please be patient. So I will be talking about cross-examination and role-playing as we go. And maybe what I'll do is I'll dedicate an entire Wednesday show, which is uninterrupted, where we can address that. Or I could just do a series of videos because we really need to. It looks like we've got to step things up for cross-examination. Some people don't feel that they are good at ad-libbing, that they believe that it's just off the cuff. And it's not as off the cuff as you may think. And that's why it helps to do the role-playing. The principles underlying what we're doing are what are important. And to help you along the way, we have 6 honest men that go with the Socratic method. Their names are who, what, why, where, when, and how. Why and how. Very, very, very important questions. So when you're asking for evidence, when you're asking something in cross-examination, if you feel stumped, if you think that you're stumped and you don't know where to go, you've got their statement. Look through the 6 honest men. Who, what, where, when, why, and how. One of those is going to be appropriate as a follow-up question. So keep that in mind. It is the underlying principles. It's the tactics. It's not knowing every single response known to man. No, you don't need to do that. And typically we're hearing the same old crap over and over again. It's, like, what about the roads? Stupid things like that. Or if it's veganism, Plant Lives Matter said no vegan ever. Stupid things like that. So don't feel so pressured that you have to be able to address every single stupid thing that comes out of their mouth, because you can be guaranteed of one thing. If you're doing a cross-examination and you are hammering away at the evidence to support their basic claim that their rules apply because you're physically in Australia or you're physically in Canada, I can guarantee you they will not be able to give you any evidence, that meaning facts or information that prove the proposition is true. They won't be able to do it. Everything else is distraction. So that's a big help right there. Objection relevance. Objection lack of foundation. Objection assumes facts not in evidence. So let's go to our first caller. We have area code 904. You're live on the No State Project. What's your name? Where are you calling from?
Hey, I'm Daniel. I'm calling from Florida.
Daniel in Florida, what do you have for us today?
Well, right now I'm going through 2 court cases. Basically, I had a warrant out for my arrest for not paying a court fine. Basically came from judgment that I had an accident when I was in high school, when I was a minor. Went to court. I was telling him that I wanted to represent myself in the matter, and he was like, "You can do that." But long story short, he ended up locking me up in jail, and I ended up spending some nights in jail. But when I got over to the jail, I had some bogus charges stating that I had assaulted 3 officers in the courtroom. Now, right now, I go to court actually on Monday and on Thursday of next week. And this happened back in February. But I go to court for those this week. And I actually kind of really need some help because I really don't know where to go at from here. I end up hiring a lawyer, which it doesn't, I don't want to give any prejudgments, but it doesn't seem like he's been of much benefit, should I say. And that's basically where I'm at right now.
Well, there's not a whole lot we can do. You got a trial on Monday. As long as the attorney is... Sorry?
It's a status hearing on Monday.
Okay, and then there's a trial on Thursday?
No. The first one is for traffic tickets. I have two traffic tickets that I have to handle, and then the second one was for the felonies, where they say I beat up officers in the courtroom. Now it's crazy thing because I asked the lawyer to ask for the tape from the courtroom, and for some odd reason they don't have the video evidence.
Oh,
Only
so
thing they have is audio.
there was a recording made, but they don't have it.
Apparently, I would think that
Pretty.
all of the the in court cases would have video, but when I asked him to do that, he tells me that the judge didn't hit the button for it to record.
Oh, yes, because the judge is responsible for that. Of course. Yeah. Oh, I believe them. Well, so how many police officers are you accused of attacking?
3 police officers.
Wow.
Now,
Wow.
the crazy thing is, there's no way I could have attacked them. When they approached me, I had my arms across my chest and was still talking to the judge at the time.
So they're alleging that for no reason at all, you just up and attacked 3 grown men.
Right.
Wow.
Yeah, I have the papers here, if I could pull them out here. But they were just basically stating that I started one of the police officers, and that's the crazy thing, because the report states that one police officer came from another room on a distress call, a distress alarm, I'm sorry. But when he comes to, in my courtroom, he states that he sees me elbowing and I guess punching or something, attacking other officers. Now, he says there's a distress alarm that he responded to, but for some odd reason, the judge didn't hit an alarm of a distress on the inside, from my understanding. You know what I'm saying? Because if I'm in the court and he's calling someone from another courtroom, I'm pretty sure that there must be a distress alarm signal. So why isn't the videotape on? So, but
well, because the videotape doesn't support the prosecution's case.
Yeah, I kind of figured that.
You know, I could see video not working in 1987. You know, but
yeah,
more than half of millennials have an HD recorder in their in their hands or pockets. Well, you know, I mean, anytime you always hear, oh, it malfunctioned. Oh, bafunkel, you didn't malfunction. You malfunctioned, and now you don't want to be held accountable for it, you jackass.
Here's another crazy thing too, because they basically had that clip.
Well, hold on about that crazy thing. We'll get back to that in just a second. We are up against the break, which is part of this Saturday show, but we'll be back in just a few moments. My name is Marc Stevens. You're listening to the No State Project here on LRN.FM and the Liberty Radio Network. 3 hours of anarchy radio right here every Saturday on the No State Project. We'll be back with Daniel in Florida in just a few moments, so don't go away. Yes, welcome back to the No State Project. I'm Marc Stevens, website marcstevens.net, where you can get a copy of Government Indicted that has a complete model for how to effectively defend yourself against these bureaucrats. And let me make this perfectly clear. This is not about going in and abiding by their rules and trying to show that they're being unfair under their own, we are showing that they have no case, period. We are not assuming that government is legitimate for a second. We are seeing them as the criminals that they are. We only appear to treat them with respect because we don't want them to hurt us any further. We're damage control. We're trying to keep and limit the amount of damage that they are trying to do. We are not assuming that they are a valid organization because they are not. But Mark, no one's ever going to. We have another success story from Ginger. An order that was very explicit. Once again, evidence that will be pissed on, and people trying to convince you that what the written word says it doesn't mean it. Marc Stevens, jackass, that doesn't mean it. So let's get back. Because apparently people in Florida who work in the court system watch Walker, Texas Ranger, way too much. People just don't all of a sudden attack police officers. One guy does not typically try to take on 3 guys. But idiots who think that Walker is real apparently do. That's the thing that gets me, Daniel. If you ever watch that ridiculous TV show, Walker, Texas Ranger, every single time Walker approaches somebody who's under investigation, they will always attack him. And you would think that after 5 or 6 shows, the writers would have moved on to something else. No. Every single encounter, everyone attacks the cops in that world. So anyway, that's what I was thinking about when you were telling me that you supposedly attacked 3 cops. And let me ask you real quick, because you said there was another crazy aspect to this. Are you 6'9" and 300 pounds?
No, sir.
So what size of an individual are you?
I'm 6'2", about 220.
Oh, okay. So a decent-sized guy. All right. Well, not a mountain, but still to attack. Hey, a 6'2", you're usually not going around attacking 3 guys at the same time. But okay. So what's the other crazy aspect of this?
Well, it's 2 other crazy aspects. One of them, they said my charges was battery on a Leo twice, resisting arrest with violence, and also battery on a 65 or older with a deadly weapon.
Deadly weapon? What was the deadly weapon, allegedly?
That's I don't know. I guess my body. I went through the scanners when I went in, so I can't understand exactly what the deadly weapon would be either. So. And
you have an attorney that you're working with, and
right.
You haven't seen.
Now, this is the other crazy part about it. I told the attorney that there was another lady that was inside the courtroom with me who was supposed to go after me, and to see if we can at least subpoena or get her name or something so she can testify to say what actually went on in the court. Well, he asked me, do I know her name? And I'm like, no, of course I don't know her name. So he was like, well, if you don't know her name, there's nothing we can do. I was like, well, can't we at least go back in the records and, at least get that information? He was like, well, no, not without a name. There's nothing we can do. So it kind of leaves me stuck, what I'm saying? It seems like I have no evidence, or all the evidence that supposedly they have is all up against me without any true evidence being shown.
Well, there's got to be some other people that were in the court that day that there's a docket available so that you can call, you can have other people questioned and see if, because they're probably just calling the police officers as witnesses against you, but you don't know. You have to find out the status hearing. There's not too much we can do right now because as long as you have an attorney who's representing you and is in standby, there's nothing that you won't be able to offer any argument. You won't be able to object. And if he's not up to challenging the foundation of the prosecution's case and wants to be a douchebag like all these critics and just want to say, well, you have to accept that they're legitimate and you can't challenge that, then there's nothing you can do. But if he's going to be rational and be an adult and actually go and try to defend you and will not give the prosecution a free pass, great. I'm not banking on it, though.
Yeah, because I just recently asked him just this past week if there's any letters or any documentations that we can send into the courts to hopefully get all of this stuff dismissed and make sure nothing gets on that record, because I want to, return back to my field. And he just kind of smirked at me, and I'm not too sure what that's supposed to mean, but I was trying to at least see or set, try to make sure that he can give me an appropriate response to that, because it seems like we've been sitting on this case for like a month and a half with nothing progressive in my defense, so to speak.
Well, I would imagine. Well, what I would do is I would push pretty hard at the status hearing, but again, if the public defender or the attorney is not going to relay that to the prosecutor and hold their feet to the fire, as far as jurisdiction, witnesses with personal first-hand knowledge, where the hell is the videotape? Is it an aberration of it? Are they claiming that for this one particular episode that there's no video, or are they going to come out and say it's not typical for them to video everything? Which that doesn't sound right to me. They had video of that one altercation where the judge started screaming at a defense attorney and challenged him to go outside and fight. It's all on video. You and I may not be able to get that video if we're not involved with that, but certainly if you're involved with something and they're trying to use what happened in court against you, that videotape is definitely subject to discovery. I mean, the prosecution has got access to it, so there's not much we can really do at this point. I mean, we could, you're going to have to see if the attorney's going to want to play ball and actually not give the prosecution a free pass. A push for that videotape, too.
All right. Yeah, I just really need help. I just don't really feel comfortable even with the lawyer that I went and hired.
Yeah, well, I don't blame you. They have I think lawyers have limited use. Most of the time, I think they're a complete waste of time. I think they're actually a detriment to people. They waive probable cause hearings, which is insane, unless somebody has done a violent act for which there is video. Oh, yeah. I'll skip the joke there, but just see if he's willing to challenge the underlying premise, the base of the foundation of the prosecution's case. You're physically in Florida, their rules apply, and that gives them jurisdiction. And everything comes from that. If he's not willing to do that, at least see if he'll go standby so that you can do it, and he's still there and is able to, still offer you some help that, as you need it. Hey, you got to find out about the videotape. You got to find out what the what the policy is. You got to find out what the basic procedure is. Are they always videotaping, which they probably are, and just how much is missing from that day? Is the whole day gone, or is it just this instance? And if it's just this instance, boy, that's pretty damn shady. That's pretty shady. But, I have to admit, I do have a bias against them because they are crooks, and they lie so often. And that's just something I was born into. How do you know a politician is lying? His lips are moving. That's much older than we are. So I appreciate the call. Definitely email me so I can get you in touch with Shem. My name is Marc Stevens. Okay. This is the No State Project here on LRN.FM. We'll get back to we got a lot of calls to get to. We're going to do our best to get to everybody, so don't go away. We'll be right back with those calls and more. Yeah, welcome back to the No State Project. And trying to get to all the calls. We're going to do our best to get to everybody. We're still doing pretty damn good on time. Haven't even finished the first hour of Anarchy Radio here. And one thing I point out right before we move on real quick is if the prosecution can't show that there's a history of violence with Daniel, they're going to, Mike, this should be a no-brainer because there's a whole escalation thing. People who, you don't normally just out of the blue attack 3 people. Someone like that is either on drugs or has a fairly long history of violence, and people typically don't start their violent careers by attacking 3 police officers at the same time. 3 cops. It's just ridiculous. I know people that have been prison guards. It's amazing how the stories that you'll hear. That one in particular who's 6'6". Well over 300 pounds, claims that people attack him all the time. All the time. Yeah. There was one time a guy 5'6", 5'7" attacked him. Can it really be construed as an attack at that point? How's a 5'6" guy under 200 pounds attack someone 6'6", about 370 pounds? Oh, please, you're lying. Look, politicians, bureaucrats, if their lips are moving, they're lying. At best, they're telling, unless they're threatening to hurt you, it's at least a half-truth. If they're saying they're going to hurt you, then you could take to the bank. That you could definitely count on that. And why are they crooks? Why do we say that? Because we're forced to pay them. End of discussion. There's your evidence. Irrefutable evidence. Well, we have another new call. We have all new callers today. This is great. Area code 970. What's your name? Where are you calling from?
My name's Ron. Can you hear me there?
Yeah, Ron, where are you calling from?
Colorado.
Colorado. Well, what do you got for us today?
I got a couple of questions. I'll try to be quick here. I was charged with an infraction. My windshield was cracked. They said that was a crime. I asked questions. They basically said, we're tired of you. They busted open my driver's side window, threw me on the ground, threw me in jail. And since then, the court, the judge has been acting as the judge and the prosecutor. The prosecutor said absolutely nothing this entire time. And so I have a couple of questions. He's supposed to be the disinterested third party, but he is the only one responding to my affidavit. Are you there? I heard
Yeah, I'm here.
Oh, maybe my phone's ringing. Oh, somebody's calling me. I'll just ignore it. So the judge is the only one who responded to my affidavit, either no or denial. And there's no response from the prosecution or the agent, who is a fiction. So I'm wondering, first of all, can the judge respond for the prosecution?
Well, it depends on the context that we're looking at here. My first question is to you, who has the burden of proof?
The prosecution.
Why are you submitting an affidavit then?
I am trying to maybe erroneously negate any of their presumption and assumptions.
Wouldn't it be better to negate somebody's claim or allegation by just asking for the proof that the allegation is based on?
I have done that.
Okay.
I've done everything in a negative environment.
But no, that's not. You see, that's not the same thing as asking or pointing out that there's no evidence. I think it's a hell of a lot better and a lot more effective. And I've got 2 new success stories to attest to it, to add to the pile of evidence that it's more effective. File the motion and just point out they don't have any evidence. Yes, it's an affirmative statement, but it keeps the burden on them. You don't have to take a position other than prosecution hasn't presented any evidence. You submit an affidavit, the prosecution doesn't have to respond to that.
Okay.
So if you had filed a motion and you filed a discovery request and a Brady request, let me address this real quick. I know discovery may be considered premature at the beginning. Brady isn't. So that's why we still file it. And so anyway, if the prosecution isn't saying anything at that point, now there's a problem for the prosecution because now they're not meeting their burden of proof. Now you've got something with teeth. Now you've got a situation where the prosecution is arguing knowingly without evidence or a qualified witness. That's got teeth. But I'll tell you right now, Ron, it's like a joke. How do you make a lawyer, how do you make a prosecutor, keep his mouth shut? Ask him for proof. It shuts them down. Why? Again, I'll keep referencing it. Watch the Ian Freeman of Free Talk Live and of this network. Watch the DMV hearing I did on video with the psychopath Michael King. The prosecutor does not say a single word in her own defense. And I'm not exaggerating, nothing. It wasn't until I was cut that she all of a sudden could talk again. It's almost like you put me in a room or on the line with a prosecutor and they're physically unable to open up their filthy mouths. Okay. So for everyone listening, no more of these affidavits. The only time you would do something like that is in here you may actually have cause to put an affidavit in the record regarding the brutality of the police officers. So let me see if I understand this right. They were complaining to you because you had a cracked windshield, So they broke your
Correct.
driver's side window?
Correct.
That makes sense. That makes
They
sense.
told me to get out of the car, and I said, no, I'm going to get out. You're going to say I attacked you. I'm sitting in my car. They said, get out. I said, no, I fear for my life. Broke the window, dragged me out, threw me on the ground, arrested me, threw me in jail. So that was that. Okay.
Wow.
So we need to file a motion, and basically, what would it say? As far as looking, because I've asked to what is in the record. I went to the courthouse. What's in the record? They said the only thing in the record is the complaint. There's nothing else in the record.
Right. That's all you'll have at this point. Now, the motion to dismiss is based primarily on a lack of evidence, that the prosecution has not submitted evidence for certain things. The biggest one is that their main claim, the foundation of their claim is, and they'll tell this to you, there's no guesswork here. If you're physically in Colorado, the Constitution, a written instrument, applies to you and gives them jurisdiction to investigate and stop you and arrest you and charge you. That's the foundation of the prosecution's claim. Anyone tells you otherwise, they're lying to you or they're just grossly misinformed. From that, not only is jurisdiction established, an element of what they're charging you is shown. It's because they're not just alleging you violated the law, because by definition, to violate the laws have to apply, right?
Say that again. I didn't quite catch that last part.
If they're accusing you of violating the law, they are. It's implied in there that the laws apply to you in the first place, right?
Right.
Right. That's an element of the charge because it's not a crime without the code. It's a code violation. So it doesn't. This windshield crime only exists by virtue of someone said it was a crime, not because of the actual nature. So it's the difference between mala in se, which is a real crime. It's criminal because its very nature, whether it is a government or not. And then you have mala prohibita, which is the windshield charge. So that charge doesn't exist. It's not a wrong or a crime without the say-so of some politicians. So it's an element of the charge. So what we're showing is not only is there no evidence of jurisdiction, there's no evidence of a valid charge or a cause of action because the most important aspect of a malaprohibitive charge is missing from the complaint. It's just not there and couldn't possibly be. So that's the basis of the motion to dismiss. So when we get motions to withdraw from the prosecution because the prosecution has a lack of evidence or insufficient evidence, it's because we have raised that issue first. Duh. But hold on, we'll be back and get to more of this in the first segment of the next hour here on the No State Project. So don't go away, everyone. All right, we got about 4 minutes, so let me mute you up. I gotta take a walk. Welcome to hour 2 of 3 hours of Anarchy Radio right here on the No State Project, here on LRN.FM, the Liberty Radio Network. Join me here, 218-632-9399, passcodes 2020 and the pound sign, and that's 218-632-9399, 2020 and the pound sign, and on Skype it's Frank Rizzo 3. Frank Rizzo with the number 3, but instant message me first. Don't just call. Reserve that more for the Wednesday show, which we will be back here live absolutely on Wednesday. Commercial free. And I want to get back to Ron in Colorado. Ron, welcome back to the show. So what we were talking about before is what the motion to dismiss is about, and also the Brady request, which is asking for the proof that we know the prosecution doesn't have, but on the Brady, if he doesn't have a qualified witness, then he's still planning on calling him, he is required to disclose that to you. So
they have sent. The only thing that the prosecution has sent to me is a list of witnesses, which includes the cops. Now, let me ask you real quick, the Brady request, I've looked up a practical guide to Brady motions. Is that something I should look? I don't know what the Brady request is, so I just looked that up, and that's what I came up with, is that can help me.
Well, I have a template available that comes with the motion to dismiss, and what you're asking for is basically you want the evidence the prosecution relies on to support its allegations, and we're putting a priority on, of course, the foundation, which is you're physically in Colorado, our rules apply, because God or someone said
Right.
so.
I get it.
And we want the proof of that. We want the proof. Not only the proof, but we want the names of the witnesses with personal knowledge who are testifying you broke the law and that the law applies to you. So a lot of it does come to a head at the trial if it's not thrown out, because you're objecting to the cops being put on the stand because the prosecution hasn't said yes or no, whether they presented nothing that the witness has personal knowledge of the matters they're testifying to, and that matter being that the laws apply to you because you're physically in Colorado. So they're going to insist that they do have such knowledge and that it'll come out on cross-examination, which it won't, which is why when I started the show talking about cross-examination, which is why they will always impeach their own witness. They'll come back, and once you start asking questions properly on cross-examination to bring out, hey, you ask them, but the cops are going to testify that they determined that the laws apply to you because you're in Colorado and they had jurisdiction to stop you. They're going to say that. They'll agree to that.
Right.
But the prosecution doesn't want them to have to answer any questions regarding the evidence that their claim was based on. So what happens is it comes out that they lied. When they say the witness is not qualified to testify, you say that is prosecutorial misconduct, is it not? You just said before direct examination, you fought me. You little man, you fought me to put this cop on the stand. You were so desperate to get this scumbag on the stand. You lied in front of everyone saying that he had personal knowledge. And the first sign that your witness is going down, you object and impeach him for me. That is not only a Brady violation; it is prosecutorial misconduct. It's and so that's usually where, unfortunately, it's going to come out, where he has no defense at that point. Okay. Of course, the judge may back him up.
Say that again.
The judge will, support him and not hold him accountable most of the time. That's because the judge and the prosecutor are on the same team.
Right, I understand that. So let me ask you this, because now we've already jumped into court, and I would like a trial, which the judge says, well, we're going to take this to trial. He didn't really ask me. He just said that's what we're going to do.
Why would he ask you?
Say that again.
Why do you think the judge would ask you if you wanted to go to trial?
No. I'm sorry. He just said, I'm going to put in not guilty for you, and we're going to take this.
Yeah, well, are you aware of when we filed a motion to dismiss and we always go into court with an unsigned plea of guilty, and when they run over the motion to dismiss and they don't want to hear that and they just want to prosecute you, then we tell them that we're intending on pleading guilty. Now, are you familiar with that process?
Saw that video late, after the fact.
Okay, all right. So we no need to go through that again. Well, have you had a pretrial conference?
We had a pretrial conference, and then we were going to pretrial. The officer was not going to be available. The judge claimed that he had dental surgery. So they rescheduled both pretrial and court. I'm assuming I'm making this up, but I'm assuming that I did something that threw them off, or it was just simply that their officer wasn't available for pretrial.
The police officer is not required to be there for pretrial unless the police officer is acting as the prosecutor.
I actually have a mistake. That was the day of trial. Right? Yeah.
Oh, so what happened with your pretrial?
I'm sorry, Mark. Maybe I'm getting my days confused. No, that was pretrial.
the cop is not required to be there at pretrial. That there's something again, unless it's a minor traffic thing and the cop, or you're in New Hampshire or Maine or one of these places where the police actually do the prosecution, which it's usually not the guy who arrests you anyway, unless it's minor thing like here in Arizona. The cop is only the prosecutor has to be there for a pretrial. Hell, the judge doesn't even have to be there. It's between you and the prosecutor.
Right. Well, the prosecutor isn't saying anything, but let me throw some other things in there that might be important to you. When, because I've been messing with this stuff for a few years, so I got rid of my license, got rid of my insurance, got rid of my registration. That's not what I was pulled over for. The lights came on when I backed into a parking space, and he saw my cracked windshield after he followed me. Then he said, "You got a cracked windshield." Didn't even check the other stuff. Threw me on the ground, so on and so forth. At the pretrial, the judge just simply said, "Hey, I'm having dental surgery. We're going to set this off and redo pretrial and trial."
Okay, he's redoing the both of them. Okay, so you still have a pretty good chance of confronting the prosecutor at the pretrial with the Brady Vike. So I'd get the motion to dismiss and the Brady request in there as soon as possible.
Okay, I will. I'm going to assume, because the judge denies everything, that he's just going to say no.
Sure.
I'm going to deny that motion, and that'll be done in trial. The evidence will be presented in trial. So I'm looking for the answer to that question when he does that.
Well, you can say, sir, objection. I need you to clear something up for me. Are you telling me that the prosecution has no prima facie burden, that he just has to make an allegation and then go to trial? That's what you're saying. He has no prima facie burden at all.
Okay.
And he may say, no, he doesn't. I need you to be super explicit, because I don't think the appellate panel is going to believe me when I say that that's what you said.
Can I put that on and for the record? This is what he said.
Yeah, I don't look. I'm a simple guy. I don't go for all this flowery language, and I don't think it's necessary. There are people that go into court, and every single question, sir, foreign on your record. But look, just say, sir, because there's already a record being. There's no such thing as off the record. That's the movies. So just ask him the question, because saying that he has no prima facie burden, he's lying to you, flat out lying to you. So we're out of time. So if you have any other questions, give a call to the on the Wednesday broadcast where we don't have the commercials, but we do have a full boat of calls. So I do appreciate it. Stay in touch. My name is Marc Stevens. We're just talking with Ron in Colorado, and we'll be back in a few moments with more calls. So don't go away. Yes, welcome back. You're listening to the No State Project. Get your copy of Government Indicted Today at markstevens.net. Full model of the tactics that we use. Examples of train wrecks, examples of when it's effective, and why it's effective. And we've got two more that I'll get into. Two more success stories and documentary proof. There's a good one. It's always good. Ginger's had a bit of success, and so it's really nice to have it when it's this explicit. And so I'm hoping to get some video with Ginger himself on Monday, so we can look for a video of that. And we'll get to your calls. We have area code 936. You're live on the No State Project. What's your name? Where you calling from? I've been on hold for over an hour, so I understand. Area code 530. You're live on the No State Project. What's your name? Where you calling from? I can hear you back there. All right, I'm going to...
Did you hear the clicking?
Yeah.
I'm trying to copy and paste this video, so I'm trying to make a little series of my own.
Okay, so I'm going to mute them back up there. We'll get...
Yeah, mute me out.
All right, let's see. Do we have area code 936?
530. crimes too.
Yeah. Is that you? All right. Well, what's your name? Where you calling from?
This is James from Big Texas.
James in Texas. You're going to have to turn the feed down.
Well, I got 3 devices here. It's hard to see which one since I'm converted into the tablet onto the computer while using the telephono.
All right. Well,
Those 3 devices.
Well, what do you got going on?
Well, there's a lot going on, man. Polk County's dirty. None of them could even begin to understand. Dayton, Texas. Houston's actually doing something to at least stop penalizing for, what do you call it, where they charge you all the extra income tax to get your license back.
Okay, I need a little more detail.
Well, they're doing what would you call that? Reform. No more penalties. Like they charge you, what is that, through the DMV? You got to pay $2,000 in surcharges in order to get your license back. So it's like 3 times the damage.
Holy crap! I think I'd just go get it somewhere else.
Yeah, well, I don't even want it, but I mean, yeah, exactly. I mean, so when you go into these courtrooms, you're not only have you not paid off your surcharges, but here you are again, traveling freely, but you're being cited to be as a criminal because you decide to get out on the road that's public right away, and you're a criminal. I don't care who you are. You get out in public, you're a criminal. That's what it boils down to.
Yeah. Yeah, and people don't understand how, a circle of poverty and how government can keep people so poor. And this is a pretty good example, where you're kept in perpetual debt to these people. And it's very difficult to dig your way out of it because, like you said, it's 3 times. And heaven forbid you want to appeal it, you have to have 3 times the fine to appeal in Texas, depending on where you are.
And then you're punished for just learning because you ask them relevant questions. And none of them, the so-called entity of a government, can help you. Well, so you're in the dignity and the peace for the people, as you state on the affidavit, in dignity of the people, in dignity of the peace of the people. But you won't help me bring remedy. Now, that doesn't say that your corporation is for the people by the people. In no means.
Oh, okay. I'm getting message that we're getting too much feedback from you, so you're going to have to turn off the other devices.
I'm probably just speaking very fast.
No, it's feedback.
No. Okay, let me power this off. I'm hoping that it transmitted. Okay, yep. Close that down. Close this down. Is that better?
Well, see, it wasn't coming. It's coming out over the air, so I wasn't aware. But I still can hear myself behind you.
Well, that's probably just technology makes sure that we can't communicate.
Well, I want to put people's. I know you're kidding, but there are some people that actually believe that this show is on. Is so large it can influence social change, and that the spooks are doing everything they can. No, we just have basic lack of a budget type of problems here on the show. Okay, so
very yes.
So let's get to the heart of this because I got a lot of calls to still get to. Yeah,
the heart of what is the heart of it? Free the weed, no stay project. That's what I say.
But I mean, do you have outstanding fines or whatnot that you can't get another driver's license, or they won't reinstate it until you pay all these thousands of dollars?
That's exactly what it boils down to. I'm dealing with Pearland, Brazoria, and Galveston. And like I said, I do a FOIA request on all their information. The appointed, she wouldn't let me defend myself, which I do already have videos on my YouTube page where the judge basically would not answer anything, even though the prosecutor had answered the questions, the questions that you put out. and as well as many others. But you could bluntly, she just made a decision to call me in contempt of court with no fair and meaningful hearing whatsoever. I mean, it's just.
Okay, so let me try to make some sense of it. Do you have traffic court judgments against you?
Yes.
And have you been able to appeal them?
I've appealed them verbally, and that's it.
You can't.
I don't want to put in. I don't put emotions. I don't put in affidavits. I go in there and.
Come on, James. When you're in Rome, there are certain things that we have to bite the bullet. I don't like paying taxes, and I will truthfully say that I avoid all the ones that I practically can. I have to pay to broadcast this show. I have to pay some federal taxes. There's no way around it because I'm paying for an IP. I have a host for my website. There's taxes. There's nothing. So here. If you have the opportunity to file a motion to reconsider and challenge them on jurisdictional charges, which you can do at any time, then I would suggest doing that. But if
I challenge jurisdiction from the get-go.
Yeah, but you have to now. You have a judgment.
Well,
hold on.
And I've got recordings.
But Jay, I got to put you on mute for just a second. And we're up against the break here on the No State Project. We'll be back with your calls and more in just a few moments, and we'll wrap up with James in Texas. So don't go away. We got a lot of stuff to get to, including another success story. Yes, welcome back to the No State Project. May 20th, 2017. Glad to be with you. Make sure you check out markstevens.net for the podcast and go to and I'll have the on the YouTube channel also some video of this show when I get back to the issue of cross-examination. But I want to bring James from Texas back up. And I would suggest that the way we don't want to do this is if we refuse to file paperwork, you have a pretty good chance that you're not going to get too far. You could do a pretty good job on cross-examination, maybe get it tossed out. A lot of times we do, but you got to...
Let me intervene right there. But I see, as a man, I want to talk to each individual that's making that claim. So through the process, will let me speak with. See, if I'm having to put an affidavit in or anything in, let me speak what my affidavit is to that man, to that subject matter jurisdiction of what they call jurisdiction over you. But if they can't answer your questions, then and you can't speak with them, that just proves that it's just an entity, and they throw all these procedures and rules and statutes and codes to throw you away without ever speaking with you. So who are you speaking with? Is this, again, just like you always say, it's just a summons of nothing, a piece of paper, something that's on a piece of paper that says that you hurt, injured, or harmed, but has no backing, no whatsoever.
Well, there's just a gun. Well, there's a gun behind it. However,
so I feel threatened. I don't care if it's with a gun or a slingshot or your word of mouth. Your mouth is your gun. That's what you speak, and you have this claim upon me when I have not done nothing to nobody. I'm a good man out here trying to take care of what exactly I need to survive in this BS world that we call government.
Yeah, but James, what we're trying to do is, you look, we are communicating directly with the individuals who are making the claim. That's why the motion and the Brady request goes to the police officer if there's no prosecutor, or it goes to the prosecutor, of course, if there is.
That's true.
And whether they're going to respond.
Through what news? Social media. Only through social media, so it's going to take it's going to take people to rise up, and we start rising up to where Austin, wherever it may be that you need to go speak up, and people get off of their morality and start doing something instead of typing everything that they want to complain about, and they know that's not law, it's not just, it's nothing right about it.
Yeah, but we're talking about getting this particular issue taken care of. Okay,
exactly.
And as far as doing this situation and getting out of it, if you don't file some kind of paperwork, and then if the reconsideration isn't granted, then at least you still have an opportunity to appeal, and you could put in a notice of appeal. But if you're not, I mean, we have had success.
That's not true. That's not true. What if you have bear witnesses? I've got friends that I show this to, and they are my witnesses to it.
To what?
I shouldn't have to.
But this isn't a matter of woulda, coulda, shoulda. We're talking about how do we effectively limit the damage or get these things tossed out. And
absolutely,
you have, and unfortunately,
now we're talking.
But unfortunately, that includes paperwork. And we've had things thrown out on appeal. We have had that. We just posted one not too long ago. So, but you're going to have to, you're going to have to file some paperwork, and because you're not going to get an appeal just by saying, "Hey, I appeal this." Unfortunately,
cast that spell, right? You got to cast that spell on the four corners so that they know absolute.
I don't even know what that's supposed to mean, but you put in the paperwork because it gets the process started. Unfortunately, there are certain things that we do have to comply with in order to meet our objective, and filing a written notice of appeal and a written brief, unfortunately, is one of the things that we have to do. So that's what I would recommend. I would put in a motion to I would put in a motion to reconsider the judgment and vacate it based on a lack of evidence proving jurisdiction right from the start. And jurisdiction could be challenged at any time. So since you haven't done that effectively at this point, that's what I would do and put that in there. And again, if the motion for reconsideration is denied, then at least you can file for an appeal and ask the appellate court to stay all the proceedings in the court and reverse that damn decision at the DMV. But that's all
I agree 100. I agree 100%.
Okay, then that's there's the but.
There's the but. If your word, see, my word, I want to hold genuine. I'm going to try to speak the truth when I come out there. So I'm still not understanding the paperwork because I'm still having meetings of minds with this judge, this prosecutor, this so-called claim that there's no living being there. If you're calling that out, you're putting that summons into while you're in court and you're saying this, what beholds? I mean, what your word, their word, and they have no victim. No, there's nobody that could come out from the entity of the state to say that you caused them harm, you injured them.
It's true. What they're gonna say is that, and this is why, and this is addressed in the motion to dismiss. They're saying there's a legal injury to the state, which is a fiction, because you violated one of its laws. And that's why we address that in the motion to dismiss. We do address that there's no injury, there's no allegation of injury, and there's no evidence of injury, so there's no valid cause of action. So we do address that, and that's...
It must be put onto paper. It must be put onto paper. I'll do a DNA thumbprint and write it out.
No, come on, James.
Them, they should already know. That's how well these courts should already be running.
What? You don't need a thumbprint. All you need is all you need is a signature. This thing with the thumbprint and the blood and the seal. No, come on. Just you sign it in proper English. Just put an X so that they know it was you, and that's all you need to do. We don't. And
I only bring that up because of Judge David Wynn Miller, which he's
he's not a judge. Come on.
Yeah, I know. I mean, but you learn a little bit from everybody. This is how you catch on, and this is what the listeners need to learn.
No, I'm going to stop you there. But the listeners don't need to learn anything from David Wynn.
No, I didn't say that. I'm saying they needed to learn a little bit from everyone to make their conclusions, and then they got some knowledge.
No, they may be misled, and so I don't think anybody needs to learn anything. What you can learn from David Wynn and people like that is what not to do. It is to do what you can learn from them is to verify everything for yourself and not to take anybody's word for something. And that's why nobody has to take my word for what I talk about. Everything is independently verified. Unlike people like that. So, yeah, it's one thing.
That's why we put it on paper, because you explained it perfectly right there.
Thank you. Well, that's what I could recommend. That what I would do if I was in your shoes right now. I would get the ball rolling again so that I don't miss the opportunity to appeal, and I do that by filing the motion to reconsider as soon as possible. And there is,
okay,
and
I'll
just
do that in all three of my cases.
Okay, and this is for you and everybody else. You can still absolutely must file the Brady request also, because there is no time frame on the Brady. It doesn't end. You can file for Brady as your appeal is progressing through the courts. So you can have, like in murder cases, sometimes 10 years after the trial, information comes out, and it gets reversed on a Brady violation. So please keep that in mind. You file the motion to reconsider and the Brady request together. So I do appreciate the call. My name is Marc Stevens. You're listening to the No State Project here on LRN.FM. And we gotta run. My name, and we'll be back here with your calls in just a few moments. So please don't go away. Yes, welcome back to the No State Project. I'm your host, Marc Stevens. I'm going to get to the call in just a second. I just beg some indulgence here about this so-called Judge David Wynn Miller. This quantum syntax. He refers to his syntax as this is from the Wikipedia page for him. Quantum language, and there's hyphens between it. Quantum language parse syntax grammar, which he asserts constitutes correct sentence structure communication syntax. Directly from his website, for this, most of it's in all caps, and there's hyphens and colons and semicolons. For this federal Judge David Wynn Miller's knowledge of the correct sentence structures, communication, parse, syntax, grammar, performance equals CSS CPSGP are the claims of the quantum parse syntax grammar. What the? Give me a break. Everyone do yourself a favor. If you've ever heard of it, don't even. If you want a good laugh, if you're drunk and you don't have access to social media, it is something to get you in trouble, then check it. I'm not even going to waste the time I'm not even going to link it. I think I've read enough that you can understand to stay away. That look, you don't have to take anything I have to say at face value, not less than anybody does. You can verify independently everything I'm talking about. Hell, a lot of the stuff in government indicted, I put real names in of people that I've, prosecutors. You can call and ask them. A lot of the stuff, you don't even have to verify. It's on markstevens.net. You could just listen to the calls. Yeah, there's a federal court inside the Postal Service. Oh, come on. People really need help, and this crap is still being peddled. Just like the Supreme Court did not say and rule that you don't need a driver's license. They've always upheld that. As wrong as it may be, the Supreme Court is not your friend there. So when they post cases that say that the state cannot take a federal right, convert it to a privilege, and tax it, what they're talking about is the state government cannot take a federal right, convert it to a privilege, and tax it. Let's say like the Fifth Amendment. So, okay, enough about that. Enough time wasted on that. We have area code 530. You're live on the No State Project. What's your name? Where are you calling from?
My alias on Skype is Shaine. So I'm calling in. I want to touch and agree with you real quick.
I'm sorry. What was your name?
Shaine.
Oh.
Shaine. My alias on Skype is Shaine.
Yeah, we had a success story with you.
Yeah. So, I was called in to get confirmation of that. And I want to touch and agree with you what you're telling the callers by using the Socratic method and everything of just simple logic and reasoning, asking questions. It is very effective. And I'm a living testimony and witness of it, because I had a situation, and I gave you the evidence to show the dismissal of the two cases, the two felonies that would have effectively ruined my life and my work to provide for my family. But if people don't have the government indicted and your documents and the scripts, they need to get it, because that would give them especially if they just coming into this, it would give them a foundation so they can start building a path and be able to go ahead and effectively started defending themselves. And the young guy you talked to earlier, you told him right when you told him you can't really do them because he got a public defender or attorney. And on my situation, I had the same thing. When I saw the public defender was about to throw me under the bus, I had to hurry up and get rid of him and stick to my guns and what I've learned from you using Socratic method. And, man, it was so effective. I had 4 prosecutors. I got down to the 4th prosecutor before they went to dismiss the case. 4 prosecutors, and 3 prosecutors jumped off because I kept using the simple steps of asking questions, and they kept imposing that they were the interface of their criminality and everything. They would contradict themselves constantly and constant. And then I found the motions. Man, I had the prosecutor so frustrated with me, Mark, he didn't know what to do with me. It was a experience. I mean, I was like, wow. And I did it with no attorney. I stuck with it. I took what I learned from you all, and I went forward, and I successfully defended these people off me, because that's what they do. They just, for one reason, that's to take from you and control. So that's what I wanted to share with the people. And for the people who are going through the situations when police are putting their hands on you, and because you're speaking out, and or you're asking questions, and they don't like it, I said this is from my understanding, because I was in the same situation. I called, as soon as they put their hands on me, I called the ambulance. I requested for an ambulance right there on the spot, because I want documentation of it showing that they attacked me, and then I can later use that against them. Hello?
Yeah, I'm listening. I'm glad you called, because it's an important point too, because that they were felonies, because a lot of people will, a lot of critics will use the same line. It's one thing that you piss them off in traffic court with tickets where it's not a big deal and they'll just throw it out because they got 7,000 other people who are going to pay, so big effing deal. But here you're talking to felonies. And
evading in a motor vehicle and felony failure to appear, and they was talking about throwing a book at me, just because I was standing up to them. They wanted me to take a deal, and I'm like, no, I don't make deals. But they was like, okay. They started threatening me. Since you're not gonna take the deal, we're gonna throw the book at you. So yeah, it was very serious.
Yeah, and
I stayed on them. Go ahead.
Yeah, and I know there's one critic in particular. I won't say anything. Is this happened in Tennessee, correct?
Yes, Tennessee.
Yeah, well, not Texas, but because I've been accused where people have said that I'm a fraud and I'm hurting people, and that I shouldn't put information out there and suggest that people with felony drug charges should actually defend themselves effectively, because I've never had, or no one else that I've worked with has ever had success with a felony. And so I'm glad you called, because now you like we posted, maybe I didn't make a big deal about it, but I don't even remember. I may not have even mentioned in the video. Those were 2 felonies. Maybe I did, but that's a big deal, because the stress that you have to be under, because they said you ticked off the prosecution, which of course you will when you ask them to support their claims. That had to, yes, you're looking at it as a Monday morning quarterback. Well, I am, but it's in hindsight now, but that had to ramp up the stress for you.
Oh yes, it was definitely stressful. And my girl, she was there all the way to witness everything. And you had the public defender at the time when it first initiated this thing, because this thing started in 2012 and it resurrected itself in 2014, and they didn't get this case started to 2016.
Jeez.
So when they pulled me back in around about 2016, trying to basically take my life away from me. And the public defender, because they had reincarcerated me, I had to bond out. They put a public defender on me. The public defender was playing devil's advocate And hold on, this thing went off. The public defender was playing devil's advocate. Oh, he was saying, oh yeah, the system is corrupt. It's been like that for 100 years and everything. And then he's trying to get information out of me so he can run back and tell the prosecutor everything that I'm thinking in my mind. So I was feeding him what I wanted him to know, and I was watching him playing. And then once I realized, I said, oh yeah, this guy right here trying to throw me under the bus. So I said, okay, all right, we're gonna change the game. I got him off the case. And then the judge was like, he was trying to give me well, you need to hire an attorney. We have people who've been doing this for 40 years. Just giving me the whole and this is your own your own what they call it. This is at your own risk, and I would seriously advise you get an attorney. And no, I declined, and I said I'm going to stick with it, represent myself. And we went forward, and I stuck with these people. Don't just go down there on court dates. Go down there when you ain't got a court date. Keep sticking it to these people. Call these people up. Keep asking questions. Keep jamming them. And that's what I did.
Yeah, they absolutely hate being questioned because they are so dishonest and so narcissistic and full of themselves that they'll actually proclaim that they are somehow different from you and I because they can make claims that requires no evidence, but we need evidence to disprove it. Fungal, and I'm glad you called, and congratulations. The 2 felonies did better than the attorney did. We'll be back with the No State Project in just a moment, so don't go away. Let me kill the feed here and try to save some time because I am really, I got a lot of calls. Holy crap. I'm not going to get, I hope I'm going to have to talk about cross-examination after the show. So you actually did better than the attorney that was assigned to you.
Yes, I did. And guess what? After the cases got dismissed, that attorney came up and congratulated me, and the attorney friend that I knew came up and congratulated me. Wow.
So just to be, the public defender that wasn't working with you anymore congratulated you?
Yeah, he came up and congratulated me.
Damn. I guess well, wow, it's a scare tactic, and I'm really glad it turned out that way because it's because it just reminds me what was going on about the same time with Nick in Australia, where they were threatening 100 years. I mean, I can't imagine the stress of looking at the better part of the rest of your life, really, that they're threatening, and knowing that they can get away with it, that they can do those things and not bat an eye. They don't care. They'll put innocent people on death row. They don't care. They don't give a damn. So just for you on something like that, they could send you away for 25, 30, whatever, 25 years, and they won't lose a moment's worth of sleep knowing that you're totally innocent, that they didn't have any evidence to support their claim. I wish more people could see the arrogance and the criminality of these people and their supporters to turn around and say, Mark, their evidence isn't required. Are you? That's why we need to get the information and get those admissions to as many people as possible so people understand we're not dealing with a system that can be reformed. You're dealing with something that needs to be extinct. It needs to be completely abolished and never and ever again to allow that people can conduct themselves under the guise of that they are different and don't need to have evidence to support their claims. It's mind-boggling that people. I guess it's because we don't get to reach the overwhelming majority of people. I only have 8,000 subs, almost 9,000 subs on my YouTube channel. I get very, very little coverage, and I was told I'm unbookable. So it's very difficult to get the information out there, but we are, and that's why it's so important and that you called so people can see. Look, hey, if this guy in Tennessee could do it, then I can. And they can see not just yours, because now we've got 2 more. I've got 2 more, Charmaine, to add to this because of two other tickets that were very serious. These were not traffic. These were crimes, and they were both thrown out. I don't think that they were quite felonies like what you were looking at, but still. And people need to hear that, and more people need to be able to know that people like you are out there, so that they can step up and defend themselves.
Definitely, and the information you're giving is very effective. They just their heart got to be in, and they got to stick with it. It's going to be stressful. This is what these people do. You just got to know and stick with it, and no matter what the outcome, and it's like chess. You know the strategy, know your next move, know what they're going to do, and play your moves play your moves every step of the way, and keep expecting a good outcome. Don't give up. Don't give up, and keep seeking information.
Yeah,
and verifying it.
Yeah, and verify, and then double check it, and make sure that you're doing your role playing. You understand that the basic principle is all we're doing is holding them to their burden of proof, and refusing to accept that they don't have to prove that. Mark, law is different; it doesn't require. Fongo. Come. See, that should go down as one of the biggest lies in human history. One of the lies that has led to untold trauma and misery and destruction in this world. Ay vey. So, all told, how long did this take to get tossed out? Was it 2 years?
They picked it up the middle of June, and it got tossed out in January of 2017. So 2016 of June, 2017.
Oh, okay.
In of January.
Okay,
I guess 2017 of January. What was on the paper? So it didn't take 2 years. It didn't take that long to get it tossed out.
I misheard. I misunderstood when you mentioned.
They held on it for so long. Held on it for so long.
Got it. Okay, so when did it actually start?
It started in 2012.
Okay, 2012. Okay, that's what I knew. I didn't.
2012.
Okay, they just hadn't filed a charge. Okay, got it. All right.
Yeah, they didn't go through an indictment. And then when I tried to file information for the indictment, they would not give me that information for no reason, because I knew that they didn't go through a proper indictment. I knew that the indictment, they just forced the information through real quick to get me into the system, because I pissed off a judge in an earlier situation in 2014. And that judge went to them and said, hey, this guy just did something that would put the judge in a hot seat, and that he would have committed a criminal act in office, and he knew he couldn't file a legal document against me, a warrant, because that would have been falsifying a document. So he went upstairs, and that's what they were so amped up when they got their hands on me in 2016 through a warrant, and they was like, yeah, you did something downstairs, and I'm like, oh, so this is what it's about. So this is why they were trying to fully prosecute me and throw me under the bus. And I stuck with the gun, sticking to the Socratic method, filing your documents, and asking questions and stand on them, and they didn't want to play ball.
Yeah, it comes down to this. If they had evidence, if they could prove their claim was true, they would just do it. They wouldn't make up a story and saying that they're not required to have evidence, but we are required to have evidence to disprove it. Normal people, when they hear something like that, would just laugh and walk away, saying, you must be an idiot to think someone's going to take you seriously unless you have a gun. And there you go. That's the explanation. That's why they say the evidence that our laws apply to you is because we put other people in prison, and we're willing to put your butt in there too.
All right, I want to give you one more situation real quick. On the motion hearing, or when I filed the Brady request and everything you gave me, it got granted. It got granted and everything, and some things the judge was covering for on the prosecutor about the burden of proof proving that.
Wait, hold on 1 second. We're good. We're coming back live, so we'll get back to the Brady in just a moment. Yeah, welcome back. We are actually in the holy crap. Have we really gone through two hours already? We're in the third of 3 segments of Anarchy Radio here on LRN.FM, and we got some off-air commentary which will be available on the podcast with Shaine. We want to bring Shaine back. Shaine, so for those who are, you were telling me about the Brady, because initially the judge did order the prosecution to respond.
Yeah, he ordered the prosecutor to respond on Brady, but he said he was not allowed to respond about the foundation of the Constitution, the code being applicable.
Oh, jeez.
So he said that. So okay, all right. I said okay, all right. He granted that, so I hit him with the motion in limine. In the motion in limine, I asked him, the judge, to grant that the prosecutor don't allow nobody without personal first-hand knowledge of all the facts, and he granted that. And the prosecutor said, "Hold on, objection, judge." And he was trying to get the judge to understand where I was going, because he already knew that I've been questioning him on that foundation. And the judge cut him off and said, Mr. So-and-so, we got this. Everybody got personal first-hand knowledge. He said, but judge, he said, look, I'm the same judge on this case, and I'm going to be the same judge in trial. He shut him up. Man, the prosecutor jumped off the case. It was funny, man. It was funny because he knew he was not going to be able to prove his burden, his burden of proof of anyone with personal first-hand knowledge of all the facts pertaining to that foundation.
Oh, because they're even claiming they don't have to prove that. So why would they have a witness with personal first-hand knowledge? They couldn't possibly have that. But the cop isn't there to testify to that. No, just like I'm going to talk about with cross-examination. The cop absolutely has to talk about that because he is the one that started it. The cops are the ones that typically start it. They are making legal determinations. I'm not saying they're making judicial opinions. They're making legal opinions. They are applying the law to certain facts and saying the law requires X, Y, or you violated the law. So if someone is testifying you violated the law, or they've said that in prior testimony or prior statements before getting on the stand, all their prior statements regarding this are fair game on cross-examination. Even if they just said, look, even if they said that Marc Stevens is a greasy guinea bitch, right? That is, well, he didn't testify to that on direct. Who cares? He said it to me on the stop. That goes to prejudice that could be, and bias. And bias his testimony again. He hates guineas. So, oh man. No wonder the prosecution jumped up, because if the judge is actually taking and granting the motion in limine, he's basically hamstrung the prosecution. So look, if I can't argue that the laws apply, I might as well give it to somebody else. Oh my gosh! For those I mentioned off air, I'm going to say it again. We are exposing them as criminals, and we're using their own words against them. So for someone to say, Marc, they don't have to prove that, but you need evidence to disprove it, you are talking to a crook. Well, that doesn't apply in legal land. Yeah, I know. They're crooks. What more do we need? What more do you need to hear? I have on the website prosecutors themselves saying, we don't have to prove that and the judge won't require us to. Yeah, because you're a friggin' crook. It's not because I'm an idiot. It's not because I'm a schmuck from Long Island, some greasy guinea dago. It's because they're crooks. And anybody who says, I'll say it every show, anyone who tells you they can make a claim with no evidence, but you need evidence to disprove it, is a is dishonest. Dishonest. You're probably dealing with a crook. If they're willing to use a gun to enforce their baseless assertion, yeah, definitely a crook. And if they're using that to bring about some kind of political change and obedience, then they're a terrorist. So, anyway, I'm glad you called.
I definitely appreciate it. I know you got other callers to get to and everything, and I'm here, Marc. I'm on board. I'm trying to keep up with everything you're putting out. And man, I said, let's just go forward and try to make change as much as we can.
Yeah, and I do appreciate it. I don't know if you're participating in the role playing, but you're definitely an asset and would be appreciated if you're able to do that. I know Bill in New Hampshire needs some help with that. I'm going to be working with him too because he's got a trial coming out real soon. I think it's this week. So yeah, if you can jump in with the guys and do that, that would be most appreciated.
Okay, if you send me a link on the role play that you all will be on, I'll definitely jump in.
Just go into the main chat. If you're not already in it, then hit the link on their upcoming events. It'll bring you in. Let them know you were just on the show and you'd like to help out.
Okay, I'll definitely do that.
All right, appreciate the call, Shaine.
All right, appreciate you.
Bye. Wow, 2 felonies there. Now that doesn't mean for a second that if you have felonies, it's gonna be the same way. But we have another testament, or more testimony and evidence, because we have the documentary proof on markstevens.net. I posted that you can effectively defend yourself against felony charges and do a better job than an attorney. So here, yes, in hindsight, he was not going against his best interest by not having an attorney, even if that public defender was not feeding things to the prosecution. So, all right, we got somebody from Phoenix. Welcome to the No State Project. You've been very patient. I appreciate that. Area code 602. What's your name?
Oh, I'm sorry. I was just kind of listening the first time today. I don't really have a case to talk about. Am I on the wrong line?
Well, as far as a listening line, there is a separate listening line that may not cost as much that you can get to at lrn.fm.
Oh, okay.
But you're more than welcome if you want to stay on. I can just mute you. What was your name, though?
Rick.
Rick. Well, Rick, we're glad to have you listening. I will mute you back up.
All right. Thank you.
I appreciate everyone. But, yes, there is a dedicated LRN listening line that you can get on. And, again, I don't know which one costs more. I don't know. I know that I'm connected onto the caller line, obviously, and I'd have to watch my Skype, but I could do a 3-hour broadcast, and it costs like $2. But I don't know. Maybe you could check the LRN.FM, and you can see what it costs you there. So you can always get on Skype. And do it that way. It won't cost. Or you can join the chat, and I know somebody does stream the broadcast live in the chat, so that probably won't cost anything there. So let me do this over here. I'm going to put Rick from Phoenix so I don't pick that up again. And I got to take people in order. We have Al from California, and my notes tell me that you were the one who won the trial by declaration. Is that correct?
That's correct, Mark. Thank you.
All right, welcome back to the show.
Well, thanks. Got another challenging one.
Okay.
Anyway, my wife has a beauty shop, and an inspector came through, and there's a lot of things that were probably inaccurate, but they ended up sending us a citation for over $2,000 for these stupid issues on, a beauty salon, right? So I'm wondering, I think your Socratic method might work. I have to attend a hearing first on all these charges, but then you can appeal the hearing and have a court date set. So probably eventually going to go to court on it.
Well, use the hearing as an opportunity. I mean, you can request certain information ahead of the hearing. Obviously, the inspector should be there so that you can cross-examine him. So there's a lot you can get at that hearing that if it has to be appealed, you'll be able to, hopefully use against them and be successful on the appeal. We are out of time for this, so just hold on for a few minutes, and we will get right back to how to deal with this hearing in just a moment. We're talking with Al from California. He was the one that won the trial by declaration in California, so be interesting to hear So we'll be back in just a moment, so don't go away. Welcome back to the No State Project. We're talking with Al in California, and I'm not going to give out the caller number because I'm already going to be out of time. And so for the rest of what I was going to address for the cross-examination and its importance, I will do more video after the broadcast, and hopefully, well, look, I'm the way it is now, I'm not going to get the video posted today. It takes... I can't do it today, so it will be posted by Monday morning. But Calvin, we'll have the audio. We will have the audio up for the rest of the show. So you can check that out at markstevens.net. I want to bring Al from California back on, who's dealing with a hearing for beauty salon violations. They're looking for over $2,000. Are these $2,000 in fines, or is this $2,000 in repairs or things that they feel is necessary for you to do?
These are fines for various and sundry. As an example, operating an unlicensed establishment, the first offense fine is $500, but we went through the local business license requirement, and it was an unincorporated area of the county. The county said you don't need a business license. However, you don't know that the Board of Barbering and Cosmetology requires it's called an establishment license. And we never heard of that one, but not having that is a $500 fine. If you go back and apply for one, which we did and got, it's the application fee is $50, but not having it there is $500 violation. So there's a bunch of those kind of things.
Gee, all right. I thought maybe this was one of those civil disobedience where you just said Fongul and didn't get the license. What? All right. Well, you're all right. So he's issued a complaint against you and has ordered you to appear at a hearing, correct?
They have not yet set the hearing date. It says they will notify me when the hearing, is scheduled. They just sent out a response to that. I'm not. Well, my response was, I'm going to send you zero amount of money to pay for any of these citations, and I want to appeal every one of them.
Well, you still, what I again, the old default position is to challenge his assertions that he has a right or that he has any justification to order you to appear at the hearing and defend against his claims, because his claims don't have any evidence. So I would do a motion to dismiss or vacate the complaint and vacate the hearing. Any hearing date. He may deny that, but these are issues, of course, you can bring up at the hearing.
Okay, so motion to dismiss, vacate the hearing, and also, what do you think of a Brady request for information?
Well, you wouldn't call it Brady, but you certainly can request some. You can put in let's say an informal. They would probably want refer to it as a discovery request. You can ask for discovery. You can ask for evidence. Just don't call it Brady, because Brady is only applicable in criminal proceedings.
Okay.
So if you give these people an inch, you know the saying.
Yeah. So, it says, that if you're not satisfied with the hearing board's decision, then you can appeal it again, and a court date will be, set.
Yes, but let's assume that that's going to not be de novo review. So let's assume that all they're going to do is like a regular appeal. So if it's de novo, fine, you get to put him on the stand. You get to do a full-blown trial again. But see, I don't know if it's going to be that way. It may just be that the record that you establish at the hearing is going to be reviewed by the appellate court. So there may not even be a hearing in the appellate court. It might just be a matter of, this is my position, this is where he erred, here's the record to prove, and then they make their decision. So we don't know yet what kind of review that they're going to have. So there's a lot of damage, obviously, to the prosecution's, to their claims here by just asking for the proof. Now he may say things like, "I don't have to prove that, but you need evidence to disprove it." That let him say that. We use the Socratic method. We don't just shout them down. We don't just disagree with them. We want to ask them questions. So let me see if I understand you correctly. You can say things with no evidence whatsoever, right? Okay. Yeah. And if I want to prove that wrong, I need evidence? Why would I say, well, let me see if I, okay. So can I make claims against you without evidence, and then you need evidence to disprove it? So, yeah, that's the appropriate response to that, because it is laughable unless there's a gun involved, which, of course, here there is. So what you're doing is we're bringing out the double standard and showing it's not fair.
Right.
Because Hitchens' razor is applicable here. That which can be asserted without evidence can be dismissed without evidence. And so if they're going to use a double standard, it isn't possibly fair. So now you got a very serious due process violation that's much easier for us to argue and convince somebody of than to try to convince them that they're required to show evidence that the laws apply.
All right. Okay, so I'll start off with the motion to dismiss. Is it a separate motion to vacate the hearing?
No, I would put that just in the first, either in the title, motion to vacate, or just to put motion to vacate. So you want to dismiss and vacate any hearing. Dismiss the complaint and any hearing dates pursuant to that.
Okay.
And
all right, I'll probably.
And then restyle the Brady request so that you take the Brady stuff out. You're still requesting a lot of the same stuff. You're just not calling it Brady.
Okay, got it.
Okay.
Yeah, I've been successful with a couple of traffic tickets, and plus that thing you mentioned, and I feel confident that I'll probably lose, but it'll be because they're just tyrants and they want money.
Hey, you can always say, look, I am happy to pay this right now. Do you have any evidence to prove that just because I'm physically in California, your Constitution applies? Any evidence at all? I'll pay it right now.
Yeah.
Yeah, that's always an option. We always put into about pleading guilty. I'm more than happy to plead guilty. Is there proof? We don't do conditional. I just want to know if the prosecution has met their prima facie burden. That's it, which they have to tell you anyway. It's part of the process. So we're up against a break, but hey, keep in touch, and if you need some help with that, let me know.
Yes, sir. Thank you very much.
I appreciate the call. Al in California, who went against all odds and prevailed on a trial by declaration in California. We'll be back with your calls in just a moment. Don't go away. Yes, welcome back to the No Stay Project. And we'll have in the show notes linking to the article and video that we did for Al and the ticket that was thrown out. So you can see the proof there. Actually, it was I posted that December 12th of 2014. So yeah, it has been a while. It's good to hear from Al again, and looking forward to see how this beauty salon thing plays out. I hate these people. You go to a place like San Bernardino, and the place is just a horror show. Just a terrible place. And they're busting, and they're looking for more money from people. A hair salon. That's why so many people have moved to Phoenix. So, can't blame them. But speaking of Los Angeles and California, he's been on the show before. Welcome back, Angelo.
Hey. How you doing, Mark?
I'm doing good. How you doing?
Speak to.
Yeah,
Hanging in there, man.
Los Angeles, I tell you, you got my sympathies.
Yeah, it's been a still an interesting journey. I know I contacted you on Skype a couple of times about my situation, what was going on. I was just calling to add into the stories of the criminals and tyrants. My most recent experience was I took over this house that was abandoned because I found out that the lender didn't exist, which is America's wholesale lender. So I've done a lot of research into it and see what's going on. And most of the attorneys go in arguing a fictitious trade name, which is it's a nonsense argument because it's about existence, not the type of trade name that they're using. So most of those cases, all of the cases that's been reported are all unreported. Well, not reported. All of the cases that have happened are unreported. So I went in. I had beat the party who claimed they had purchased it, and then the judge penciled with me and claimed that they had properly obtained the property through foreclosure process, but didn't prove that they did it according to the rule. So, which is impossible because if it wasn't done, they couldn't prove it they had the authority, then you can't say it was a valid sale. So I go in, I prove through all the witnesses they committed perjury. I got them admitting it on the stand, everything. The judge,
wow.
Well, here's a trick part. The first judge I had, now I went in there from the first case. The second case I came back and I demurred on the complaint, showing that they didn't have any claim based on the case that they always use against homeowners, which is that you can take judicial notice of recorded documents if it's showing a legal effect. So I had legal effects from legal recorded documents and public records from New York because on the deeds of trust out here, they say that the company, America's Wholesale Lender, is a New York corporation organized and existing under its law. So the governing or the standard rule is the existence and organization of a company is determined by the company that is organized and existing in. So in New York, I called out there. I talked to I talked to the director for the legislature. So he found out what I was doing and personally sent me a certified copy of their law for businesses, establishments, and also where to get the court cases from. So I had everything like it was supposed to be, all admissible evidence. The judges ignored all of that, which basically my documents impeached whatever public records they put in because they all depended upon New York law. So the judge that I had in the first case, he got dismissed because I beat him on that one, but they refiled. And I go back, this is a eviction case. So they refiled, I go back in. The day of trial, my judge all of a sudden goes on vacation, and they kick me up to another judge on a different floor, and nobody's up there, no bailiffs, nobody, just me and the plaintiff. He ignored everything, let all the evidence in, ignored the perjury, ignored the false statements, ignored the California law, because they have the same law here.
Okay. And
New York law, and granted them judgment.
Summary judgment.
That's what I've been dealing with. Huh?
Was it summary judgment?
No, it was a judgment because we went to trial.
Oh, that's right. I'm sorry. Because it's typical with these things to be summary. I'm sorry. So they granted him judgment. Well, wasn't there a jury?
No, you have to pay for that in the eviction case. You got to pay for the juries. But with this particular rule, there's no need for a jury because it's all a legal requirement. It's all based upon do they have the right to be in court? And in every state, it's the same rule. If the company didn't exist, then they acquire no rights, they grant no rights, they give no rights. It never happens. The court is void of any jurisdiction. So all of that was just ignored.
Well, it sounds more like it sounds more like that the party has no standing to complain.
Exactly.
as opposed
Right,
to
no
that there was,
whatsoever.
yeah, because I know I have a handful of people that jump on my head every time I say something that may be misinterpreted. So I just want to point out, in federal courts, standing is jurisdiction. It's not always a jurisdictional issue at the state level. Some states do, some states don't. I don't remember if California does or not, but here I think it's
California's the same way.
Yeah, okay, so they didn't have standing to complain.
Right. Or sell the property or do anything else. But it was just, it was amazing because I'm like the bailiffs, like the court clerks, they said nobody had been through there before that knew so much about property. Even the judge I've never met anybody that knew as much as property law. I think you know more about property law than I did my first year at law school. So it was just the way that it was done. It was like they segregated me for my case because I'm the day I go in, they have the pro tem. So I didn't, they usually give you the opportunity to stipulate to the pro tem or the judge, or you want to see a judge. When I approached, because you report in, they automatically had my case already assigned. Where, hold up, your case is going somewhere else. We'll let you know where in a few minutes. I get up there, no bailiff, nobody else decided that they were going to not see a pro tem and be heard by a judge, which is, odd to at least one person will say, I'm not going to stipulate. Granted, nobody really knows the legal system, but out of everybody, usually one or two would like to be heard by a judge. None of that. So it was a devastating experience because, we were still recovering from the first issue when we got attacked with my wife. You remember that with her being a CHP officer and they're attacking her because of me attacking the traffic infraction system out here.
I'm sorry, I'm not. It's not ringing a bell.
Oh, it's been a while since we talked. You probably forgot about it, but you can probably Google this, but my argument was that California peace officers don't have the authority to stop, detain, or arrest any motorist solely for the offense of a traffic infraction because they're not criminal in nature. And she was a CHP officer at the time, and they couldn't beat me in court or do anything with me. So it was a collateral attack on her, and they trumped up some charges regarding my vehicles, my cars, which weren't, they weren't registered, and ended up booting her.
It's a dangerous game out there. Well, most places, but particularly out there. And I would probably I don't recommend. And there was a caller earlier. I didn't even get. There was so much going on. I didn't even get a chance to mention that. Driver's license is one thing. You should, but they can't see that necessarily. But you got to have a current tax tag on the car, and you should have insurance just because it's a damn good idea. We're up against the break. We're going to finish off air, and then hopefully get to Tony in California. It's a big California day, I guess. So we'll be back in just a few moments here on the No Stay Project, so do not go away. Hey, I nailed that. That was that was my best break the whole time. So okay,
I'm self on Skype, right?
Am I on Skype? That's how I'm speaking.
I'm on Skype.
Yeah. Oh yeah.
I am self. Okay, I thought you didn't remember who I was.
I know who you are. I know that your little boy has got to be at least 3 years old now.
Yeah, he's actually 5. He'll be 6 in October. Yeah.
Oh, gee. See, we never got to meet up at Libertopia. You never were able to come down. I know who you are.
I'm telling you, Mark, it's been like it's been a struggle. We've been trying to get back on our feet from that first one forever, and every time I get 2 steps up, I get knocked back 5. Trying to deal with these clowns just entrapment. When she was pregnant, I think she was 7 months pregnant, she got handcuffed. We had plates and everything, but we got pulled over by one of the Bell City police, and he's handcuffing me and her 7 months pregnant, just on some nonsense, trying to check us out. This is one, I don't know if I'm a magnet for this stuff or what, but it's crazy. It's nuts. And I've gotten real good with court and procedure and everything.
It sounds like it does, because I don't have much time because I have to have to work with somebody after the show today, so I can't go over. So You got the all right. So the judge gave them judgment. I mean, did you file to reconsider and have that tossed out?
I ran out of money, man. I couldn't. I just ran out of money, and I wasn't going to file. You know, you can get a fee waiver, but they want so much personal information. You know, it's too much of an invasion.
You shouldn't have to pay for that, though. But you shouldn't have to pay to file a reconsideration.
Yeah, well, it was because of reconsideration. You got to come in with new facts or evidence. You can't come in with the same thing.
Yeah, but
my whole position was they didn't exist at all. I mean, the law is clear. It's like there's no question that they shouldn't have that judgment. I mean, based on the facts. And in fact, the public records of New York impeach whatever they put in because it has to refer back to it. That's where the corporation was supposed to be from. So if they didn't exist at the time, it was a 2004 deed of trust or mortgage, and the company that came into existence wasn't until 2008, and they wanted the same people. They wanted the same people that organized it. It was a whole different. Somebody figured out what I did, and they went and started the corporation in New York. And they were negotiating with the homeowners, making money off of it.
So you're actually looking at a final judgment that can't be appealed?
Yeah. Nah, it could have been appealed, but like I said, I ran out of money.
Well, they might put
you like 10 grand. Huh?
Yeah, because you're going to have to put up some kind of bond for the appeal.
Right. And I ran out. I was done.
Oh.
That was our last little hope. I was going to use that to get us back on our feet.
Oh, man, I'm sorry to hear that.
Hey, it is what it is. You know, I know what the system is, but that was my point for calling in today. Was kind of share that little story to, you don't need any aid and assistance in proving that, but just goes to show it doesn't matter. Whatever they don't like, they're going to do what they want to do.
Hey, follow the money. It's like that famous line from a civil action. The system's not about justice. It's about serving those who throw the most money at it.
That's all it is.
And the banks, the banks tend to win. That's why it was so nice when we beat the Michael Scott law firm with Armando down in McAllen, Texas. You can't find anything positive about the Michael Scott law firm online. They're terrible, and we were able to kick the snot out of them, and we stuck to our guns. But it's not something that happens all the time. The banks have very deep pockets, and we're coming back. So just welcome back to the No State Project. Marc Stevens, the website markstevens.net. We got more off-air commentary for this show. We had a lot of callers. I'm talking with Angelo, who it's been a while since we spoke, and makes me really. We're trying to get something together here, so hopefully we got a few guys moving out here to the Phoenix area. We can start and pick up where Libertopia left off and start doing it in Phoenix or Mesa in January or February when it's absolutely gorgeous. So maybe that's a time that you can come out. We can actually jam because I know you're a musician too.
Yeah.
So. Yeah, it's really unfortunate. I know we talked a lot off air about what happened. Unfortunately, there's a judgment against you, and it's just a matter of money. Because in California and a lot of places, especially civil, you want to appeal that, you have to put up quite a sizable bond, and it could be in tens of thousands of dollars in order to be able to appeal. Right. And so people could say, well, you have every right. I can see scumbag Republicans saying, hey, appeal is available to you, whether you accept that. It's like with insurance. Hey, insurance is available. Yeah, but it's $28,000 a year, and there's a $20,000 deductible. It's like not having insurance. You can appeal, but when they hit you with a bond like that, there's nothing you can do.
It makes it almost impossible, right? You're limited by your resources.
Yeah.
And there's no doubt that it would get reversed on appeal. I think that the intent was just to get me out and just have me fighting from the outside because, you do have you double up even more on your costs and expenses plus the expenses of moving and all of that stuff. So, it takes a toll on you and the family.
I'm
pretty sure that's what they were counting on.
You wish that it would, and it may be that it would be cheaper to attack the judgment on a petition for a writ of prohibition than to try to put up a $10K or a $20K bond to appeal. But I don't know if that really is an option. I wish
You
Wow.
got to still pay for that. You have to pay to file that. So
Yeah.
I think that one's at $700. Then you got to do the transcripts. The transcripts, I had to get the transcripts because you have to provide your own court reporter too. There are no more courts of records in Los Angeles County. So you have to pay for the court reporter. You got to pay for the transcripts. You have to pay for the appeal, and then all the copying costs. And then when you get in the appeal, they require like 6 or 7 copies of your briefs, and it's just a mess. And some more to the Supreme Court. So by the time you get done, you probably like out of 25,000 or so, close to it.
Yeah, or more. So depending on how many witnesses there were and how long the trial was.
Right, and my trial was, I think, like 2.5 hours. 2.5, 3
that's
hours.
okay. That's not bad. I mean, if you're looking at a 2-week trial, you're going to. I mean, that's a lot of money in transcripts. So, hey, I'm glad you called. It's good to catch up. You're gonna have to catch me off air because I'm gonna do what I can to get another caller in.
I'll do that, and take care. Thanks for taking the call, and I'll talk to you soon.
Yeah, contact me on Skype. It's Frank Rizzo 3.
Will do.
All right, appreciate the call. Angelo from Los Angeles. We'll go back to California for one last call. We got Tony. Hey, Tony, how you doing?
Marc Stevens, sledgehammer in the box. How you doing, bud?
I'm doing well. How's everything in California? What part of California are you in, can I ask?
I'm still in Los Banos, man.
Okay. Los Banos?
And yeah, Los Banos. Basically, in Spanish, it means the bathroom or the showers, however you want to interpret it. But it's just Hotland, USA, man. That's all it is.
It's like Baker.
we're about 90. No, we're like about 130 miles north of Bakersfield. But either way,
Baker.
We're sharing the same climate.
No, I'm thinking about Baker, the way like on your way to Vegas.
No, yeah, we're definitely like that. Hell yeah.
Oh, man. I tell you that. This is why people probably drink so much in Vegas, because you're so glad that you're out of that horrible desert, and then you drink so much because you're like, oh, I got to go back. That, I swear to you, that is one of the worst drives. I-15.
Oh, yeah, I've done that.
Oh, I've done it many times. I-15 through Barstow and then through because Baker has that the world's largest thermometer.
Oh yeah,
right. And it's not far from Yermo. And there's a Zizix Road. I've done that road trip a lot, and there's nothing but dirt out there. It's just. Oh man, it's bad. It's bad. And when you get to Nevada, it doesn't. It's not much better. But at least the speed goes up.
With the dirt.
Yeah,
there's more shrubbery with the dirt.
Yeah, but the speed increases slightly when you get to Nevada, at least for part of it. And the worst is when you go north of Vegas on 93. Have you ever traveled that?
Yeah. No, I didn't get that far.
No, you want to kill yourself there.
Sorry. Yes, I have, because I ended up going out there. I used to road race motorcycles, so I go on out to Pahrump, and we'd head on out that way.
Yeah, terrible. You see almost nothing except for Eloy or Elo, and then you get through Caliente. All right, I'm giving myself nightmares here. But you called for a reason, not to talk about Baker.
Yeah. Just wanted to call and give you a quick update. I don't know if you remember, I called you back in January. About January, February, in regards to Los Banos PD showing up to my residence, and they ended up taking a Jeep that I had parked out in front of my house, and they just threw it up on a wrecker and they took it away. So that was one of my issues, and my second issue was I was dealing with my ex-wife's attorney, because my ex-wife didn't pay her attorney, so she slapped a lien on my ex-wife, and since my ex-wife is still on the title of the home, now there's a lien on the home, and I can't do anything as far as refinancing and all that stuff. And that's when I was turning around, I was getting ready to try and sue her to either recover what it is that I'm losing or have her just release the lien. But anyway, I got a couple of updates for you. The first update with Los Banos PD, the two officers that showed up to the house and that went through and towed the vehicle, they had to hire an attorney to represent them because I sued both of them, and I end up I have to go to court on the 23rd, this Tuesday, so that we can go through a motions hearing, and then we have a ADR case management service CMC scheduled for the 30th of this month. And they have this real big wig lawyer by the name of Gregory Myers based out of Fresno. And this guy literally is reading me the riot act of, well, I don't know what you think you believe as far as what the officers took your vehicle, and you said it was done by conversion. You didn't have your vehicle registered. They showed up, they saw it, they just went ahead and took it. I'm like, okay, I understand that. I completely understand that. But number one, no jurisdiction. They didn't even issue me a notice to appear. I didn't even get a yellow sticker put on the vehicle. And the attorney was like, well, they don't have to do that. And I'm like, really? So they could arbitrarily just show up to someone's house, do what they want, take what they please? He goes, Mr. Cook, you could go ahead and do what you want, and we'll see you in court. And I'm like, no, I'm just curious, and I'll ask you this: do you have any proof that any of the rules or regulations, codes, laws, statutes, and the Constitution apply because I'm physically in the state of California? He goes, sir, your argument is frivolous, and if that's what you're going to bring to court, be prepared to go ahead and pay their attorney's fees because that's what I'm going after.
Just one little correction. You don't want to use the word state in there, just physically in California. Keep it in lay terms.
Gotcha.
Great. So he obviously filed the motion hearing that you're going to is his motion to dismiss.
Well, no, he didn't even file a motion to dismiss. Now, get this. I know that my shot clock is running a little low here. I filed my complaint, or the verified complaint, on February 24th. According to civil statutes, you have 30 days to answer that complaint. They didn't answer the complaint, so I went ahead and filed for a judgment. And the judge who reviewed it came back, kicked it out, and he said, your judgment is denied. I'm going to go ahead and set this aside, and then we're going to go ahead and continue with the case.
Oh,
and I'm like, whoa, wait a second.
Hold on. We'll talk. I got to finish the on-air broadcast, and we'll finish for a few minutes off air. So just oh man, more special treatment. I guess Greg Myers has a reputation in the area. Well, everyone, for the live broadcast, we are out of time. We will be live this coming Wednesday. So definitely tune in for that. We'll have all the off-air commentary posted at markstevens.net. So till next time, salud. All right, so the judge doesn't allow a summary judgment or a default judgment for you because
No, he doesn't.
Did Mr. Myers give any grounds for why the judge should not allow judgment, even though they went past the 30 days?
Okay, now get this. I went ahead and I applied for the judgment, and I stated the reasons why. I gave my my affidavit of everything that took place. At the time, they still haven't answered. They didn't answer the complaint for, I think it was 56 days.
Wow.
So the judge went ahead and looked at everything, and on his own accord said improper service. So that was his reason why.
Was there anything specific to show? I mean, and this is from the judge. This isn't from Greg Myers saying, you didn't serve my client's light because of X, Y, Z. I mean,
no. And now this is the other thing, is that what I put in there for the motion to vacate the judgment and motion to rescind the order to set aside was because, number one, the defendant and Greg Myers, when they finally did answer the complaint, they accepted everything as true, and they filed an affirmative defense on their behalf, on their side. So the judge or the court already accepted everything and said, you guys are scheduled for a case management case management conference. So they accepted everything as true, according to the law. The defendant went ahead and filed their response to the complaint, so they accepted it. So I'm wondering, how in the hell can you say that it was improper service when the defendant accepted it? Even though it's late and it's untimely, but still. And I've asked them, and I'm getting no response, no answers.
It's like there's no. I mean, they can say the wrong person was served, for example, just to throw something that's specific. You served Mr. X when it should have went to Y. At least that's specific, and it's something that it's an argument that you can address. But just to be so vague about it, which is usually more when you're dealing with government attacks, what do you have to go on? No.
That's what I asked. That's what I asked the judge, and I'm still waiting to get a response.
Gee. Wow.
It's like basically you said that it was improper service. Okay. According to, and maybe I made a mistake by doing this, more or less like poking the bear that's in the cage. According to Evidence Code 451, you say that it was improper service. Who was the witness, or who is it that has personal first-hand knowledge that it was improper service? Bring that person forward. Let them go ahead and say or speak up as to why service was improper, what it was that they saw or that they know.
Yeah, of course.
Because just for you to say it was improper service, are you biased? Are you protecting these officers? So, and this is the same judge that for my civil case against my ex-wife's attorney, he kicked that out because he recognized my ex-wife's attorney. I didn't catch it until we started walking out. He asked, ma'am, can you stay in the courtroom for a second? So everyone left, and he's sitting up there talking to her and everything, like everything's all hunky-dory. And I walked back in there, and he goes, we'll cover this matter at a later point in time. So it was almost like ex parte communication after the fact.
Wow.
But
I guess you have to.
that I'm trying to.
I'm sorry.
Go ahead.
I was just saying. It sounds like a mess. Now you have to wait to hear back from the judge.
Well, on Tuesday we go in for the motions hearing because I've number one put in a motion for a preemptive challenge to get another judge. Number one. Number two, I went ahead and asked for discovery. I demanded for discovery because I've already put in requests for everything. And Mr. Greg Myers is saying, well, the things that you're asking for, we're not going to respond to because it's criminal what you're asking, and it doesn't make any sense. So when you put it to us in the proper format, then we'll respond.
You didn't ask for Brady material, did you?
I made that mistake, yeah.
Yeah. All you got to do is pull the Brady's part out. Ask for the same evidence of the cops' claims, but just don't refer to it as Brady.
Okay, because how he's putting it, you need to serve us with interrogatories and, a request for production of documents and all of this stuff. And I'm just like, oh, man, it's almost like I'm pushing a bowling ball uphill with a toothpick.
These things are not, getting into a civil process like that, yes, that's what comes with discovery. That's why companies tend to settle, because discovery can be so expensive. And if you've got a lot of defendants, like it's a class action type of thing, you have to provide copies of everything, to all the other parties. The other defendant, it's a nightmare. And just in transcripts, so if you're, let's say there's 10 defendants, and they all have their own lawyers, okay? Let's just say for sake of example, when you do a deposition, they're entitled to be there, and that drives the costs up of everything, and then you have to provide transcript. So yeah, it sucks. It really does. But there's nothing we can do about that. And that's where they usually get people. They bury you in pretrial procedure.
What I'm planning on doing basically is, and I don't know, let me bounce this off you, and I know that you're probably pressed for time because you got some stuff you want to take care of after your show and everything. During the case management conference, I'm thinking that it would be wise to probably just go in, listen to what it is that's going to be said, and then present a settlement offer with them that I'm willing to go ahead and dismiss or withdraw the suit against both officers. I offer to pay the attorney's fees for the officers, and I'm willing to go ahead and do everything that their attorney asks, just as long as they are willing to go ahead and show or provide proof, of course, of what it is that I'm asking.
Yeah, no, that certainly is an option and something that is a regular part of the pretrial. The whole point of doing a pretrial is to narrow down the issues of fact, and so there's not as one you can either have a deal or you're limiting the issues that need to be decided at trial. So
because basically he's saying my whole argument is completely and absolutely frivolous. So basically what it is since they don't have an answer, of course they're just going to call it frivolous.
Well, and you could say to him, if you honestly thought that this was frivolous, why did you file an affirmative answer? And you can say, hey, look, hey, your clients aren't here. You could be on, just why did you do that? Are you just padding your bill? You do know, a simple one-page motion to strike is all you do when something's truly frivolous. You don't respond to something that's frivolous other than to say it's frivolous because it's self-evident that it's frivolous. So.
Real quick, there are 2 entries in the Los Banos City Hall town meetings dated for January 18th and April 19th of 2017, where I actually do get up and I question not only the city attorney, but mainly the mayor. And I get on them, and they literally have no answer other than to shush me off over to the police chief. But, yeah, you can go ahead and pull that up, and you can look at it. I'm literally within, the first the one for April 19th, you have to go to, 55 minutes in. But the one for January, you go to, I think it's 16 minutes in, and then you'll see me. But, yeah, I'm the only big, large black guy that's in there.
Okay, could you send me a link?
Yeah, sure, no sweat.
Cool. Yeah, send me the link and I'll get that posted. Hey, that's hey, I'm looking forward to seeing that. Yeah, I have to help somebody who's going to court soon, and I got another video segment I've got to record because my gosh, man, we had a lot of calls today. So yeah, well, keep in touch with me and let me know what happens.
I'll definitely let you know how things go on after Tuesday, and I wanted to go ahead and find out, because I know that I'm probably going to need 1 or 2 things from you from your store as far as paperwork is concerned. So, and I've already read that a couple of people have issues trying to submit payment. What's the easy way to do that with you, Mark?
The easiest way is online is just use the Sells button. It goes right to my Sells store. So just hit the button. Okay. I know you have to hit the button again. And I'll work on getting that easier to use. So the Sells is not a problem. It works better than PayPal. They're an Australian company, and I couldn't be happier with them.
Cool.
I hate PayPal.
I appreciate it, sir.
Well, hey, yeah, I'm glad to be able to help. I appreciate the call and the update. Let us, and let me know off air, what I can do to help.
Okay, Mark.
All right. Appreciate the call.
Appreciate it.
Appreciate the call. Thanks, Tony. Tony in Los Banos, California. Appreciate all the calls. I think we got to pretty much everybody. We will be live this Wednesday. I forget what day. I don't work out what day it is. Maybe the 25th. But Wednesday from 3 to 4 Pacific time, and that is the Ustream video stream of the big show that you can get on Wednesday. Always posted, usually by Thursday morning, the video from that HD video and the better audio. So you not what you get at my Ustream channel, which you can get at markstevens.net. I appreciate everyone tuning in. A lot of great calls, a lot of good material. I will have an additional video available regarding the cross-examination issues and tactics that I did not get to cover in this particular broadcast, which was for May 20th, 2017. Again, I'm Marc Stevens, the website markstevens.net. Till next time, salud.